Welcome to INN's Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Shivani Dubey. Today she is going to speak on offences related to marriage. She is from KES Shri Jayanatilal H Patel College of Law. So without wasting further time, I would request Shivani to commence with her lecture. Thank you.
Marriage is a journey, not a destination. With this proverb, I, Ms. Shivani Dubey, my today's topic that is offences related to marriage. Marriage is as a sacred institution and a foundation of society is intended to cultivate love, trust and responsibility between people. Not with understanding the regardless and the optimistic vision of the conjugal rapture, relationship can once a while be defaced by different offences, promoting lawful repercussions and huge social outcomes, offences connected with marriage, people, families and network at large. Different laws and precedent have brought in by various courts, with the most illuminating ones being for the Honorable Apex Court. Such misbehaviors, namely adultery, discretions or cruelty amongst other, are known to be offences against marriage or matrimonial offences. In India, offences relating to marriage are governed under the provision of the British era criminal law, the Indian Penal Code 1860, that is IPS. Recently, the Bharatiya Nyaya Sanhita 2023 was introduced to overcome shortcomings of the IPS as well as to consolidate and amend the provisions relating to offences. In this we will explore the provision under the Bharatiya Nyaya Sanhita 2023 concerning the offences relating to marriage. There are several sections for that. Let's see. Section 80 speaks about dowry deaths, where the death of the woman is caused by any burn on bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it shows that soon before her marriage she was subjected to cruelty or harassment by her husband or any relative for her husband, or in connection with any demand of dowry. Such death shall be called dowry death, and such husband or a relative shall be deemed to have caused her death. Whereas dowry in this section means any property or valuable property, a very valuable security given or agreed to be given either directly or indirectly. There are 2 points: by one party to a marriage, or to the other party to the marriage, or by the parents or either party to the marriage, or by any other person to either to marriage or on any other person. Whoever commits dowry death shall be punished with imprisonment for a term which shall not less than 7 years, which may extend to imprisonment of a life. Bharatiya Nyaya Suraksha Sanhita, that is BNSS, has compiled that it is cognizable, non-bailable and trial by the court of session. Section 81 speaks about cohabitation caused by men deceitfully, including a belief of a lawful marriage. Every man who is deceit causes any woman who is not lawfully married to him to believe that she is lawfully married to him and to cohabit or have sexual intercourse with him, and that belief shall be punished with imprisonment of either description of for a term which may extend to 10 years and shall also be liable to fine. That is the discretion of the honorable court. Non-cognizable, non-bailable, trial by the magistrate for the first class. Section 82 speaks about a marriage again during lifetime lifetime of husband and wife. It deals with bigamy, which is marrying again during the lifetime of a husband or wife. Section 82 subsection 1 states that whoever having a husband or wife living marries in any case in which such marriage is void by reason of its taking place during the life of such husband or wife should be punished with imprisonment for a term extending to 7 years and fine. However, this subsection does not extend to any person whose marriage with such husband or wife has been declared void by a court for contempt jurisdictions, or not to any person who contracts a marriage during the life during the life or a former husband or wife, if such husband or wife that the subsequent marriage shall have been continually absent for such person for the space of 7 years, and shall not have been heard or by such person has been alive within the time provided, the person contracting such subsequent shall before such marriage take place inform the person with whom such marriage is contracted the steel of the real state of fact so far as the same within is his or her knowledge. Section 82 subsection 2 illustrates the whoever commits the offence under subsection 1 having concealed from the person with whom subsequent marriage is contract the fact is the former marriage shall be punished an imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Bharatiya Nyaya Sanhita is silent about the discretion of the fine. It is the discretion by the the court has given. Section 82 subsection 1 imprisonment for 7 years and fine. Section 82 subsection 2 imprisonment of 10 years and fine, non-cognizable, bailable, trial by the magistrate of the first class. Section 83 marriage fraudulent throughout lawful marriage. Whoever dishonestly or with fraudulent intention goes through the ceremony of being married knowing that he is not thereby lawfully married shall be punished imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Bharatiya Nyaya Suraksha Sanhita clarifications. Non-cognizable, non-bailable, trial by the magistrate of the first class. Section 84 inciting or taking away or detaining with criminal intent married woman. Whoever takes or ethes away any woman whom he knows or has reason to believe to be the wife or any other man with intent that she may have illicit intercourse with any person or conceals or detains with that intent as any such woman shall be punished with imprisonment either description of for a term which may extend 2 years or with fine or with both. Non-cognizable, bailable, trial by the magistrate. Section 85 husband or relative or of husband of a woman subjecting her a cruelty. Whoever being the husband or a relative of the husband of subjects such woman to cruelty shall be punished with imprisonment for a term which may extend 3 years and shall also be liable to the fine. The clarification imprisonment for 3 years and fine cognizable if information relating to the commission of the offences is given to an officer in charge of a police station by the person aggrieved by the offence or by any person related to her by blood, marriage, adoption, or if there is no such relative by any public servant belonging to such class or category shall be notified by the state government in the behalf, non-bailable, trial by the magistrate of the first class. Section 86 speaks about cruelty for the purpose of any willful conduct which is of such of nature as is likely to derive the woman to commit suicide or to cause grave injury or damage to life, limb or health, whether mental or physical, of the woman, or harassment of the woman where such harassment is with a view of causing her or any person related to her to meet any unlawful demand or any property or valuable security or his on account of failure by her any person related to her to meet such demand. Section 87 speaks about kidnapping, abducting or inducing woman to compel her marriage, etc. Section 87. Whoever kidnaps or abducts any woman with intent that she may be compelled or knowing it to be likely that she will be compelled to marry any person against her will, or in order that she may be forced or seduced to illicit intercourse, or knowing it to be likely that she will be forced or seduced to illicit intercourse, shall be punished with imprisonment of either description for a term which may extend to 10 years, and shall also be liable for the fine. And whoever by means of criminal indemnifications has defined in this Bharatiya Nyaya Sanhita or abuse of authority or any other method of compulsion induce any woman to go up from any place with intent that she may be, or knowing that it is likely that she will be forced, seduced to illicit intercourse with another person, shall also be punishable as for foresight. At its clarification, imprisonment for 10 years and fine, non-cognizable, non-bailable, trial by the court of session. There is a very landmark judgment in India, Joseph Sign versus Union of India. The case challenges the constitution validity of section 497 of the Indian Penal Code 1860, that is IPS, that criminalized adultery. The section 198 of the CRPC, that is Code of Criminal Procedure 1973, which treats the husband as an aggrieved person in the case of adultery. Section 497 IPC, Indian Penal Code, made adultery an offence only with the respect to a man who has sexual intercourse with the wife of another man without the consent or convenience of the husband. That wife is it not punishable, as in section 198 of CRPC provides that no court can take cognizance of an offence punishable under chapter 20 of Indian Penal Code, which includes adultery, except upon the complaint filed by the husband of the woman. The petitioner argued that this provision discriminates against women, treat them as a subordinate to man, and violate Article 14, equality before law, Article 15, discrimination under the sex, and 21 of the Indian Constitution, that is freedom to Constitution, which guarantee equality, non-discrimination, and protection of life and personal liberty. Section 497 of the Indian Penal Code, which criminalized adultery, has held unconstitutional as it is manifestly arbitrary and violates Article 14, 15 and 21 of the Indian Constitution. The court held that the section was based on the gender stereotypes and it treated women as the property of their husband by criminalizing adultery and punishable only men if subordinate of women, and denied the sexual autonomy, agency, dignity and privacy in a matrimonial relationship. The principle of the constitution morality, substantive equality and dignity required that married women are not viewed as property of their husband. Human sexuality and sexual autonomy, an essential aspect of one's identity. In the essence of unanimous verdict, decriminalized the offence of adultery and recognized constitutional principle of gender equality, sexual autonomy, dignity and privacy in a matrimonial relationship. The earlier judgments treating adultery as a criminal offence were overruled as being based on the unconstitutional foundation. The Bharatiya Nyaya Sanhita has introduced the concept of offences against marriages, that these are very casual and multidimensional in nature for creating fair and effective legal systems. The concerns of matrimonial ties that have to be addressed. Offences connected with marriage envelop an expansive range of offences that can have extensive lawful and ramifications. The provides a brief overview of provision concerning offences relating to marriage against women in Bharatiya Nyaya Sanhita 2023. The Bharatiya Nyaya Sanhita retains provisions regarding offences relating to marriage maintained under Indian Penal Code, but it also criminalizes sexual intercourse with women by deceitful manners. Moreover, Bharatiya Nyaya Sanhita does not include any provision related to adultery, which has prevalent under Indian Penal Code section 497, but was struck down as unconstitutional by the Supreme Court in the Joseph Sain versus Union of India, September 27, 2018, and the judgment stating that section 497 lacks of adequately determining principle to criminalize consensual sexual activity, and it manifestly arbitrary. I will conclude like in Bharatiya Nyaya Sanhita or Indian legal system, marriage related offence covered under a wide array of laws, including the Indian Penal Code, personal laws, special statutes like Protection of Women from Domestic Violence Act. India have interpreted and enforced law relating to marriage offences such as adultery, cruelty, dowry related harassment, bigamy, and domestic violence. It still remains a while adultery was an criminal offence under section 497 in Indian Penal Code. It was decriminalized in 2018. However, it is still grounds of divorce under personal laws. Other offences like cruelty, dowry deaths, and domestic violence continue to be punishable under the both criminal law and civil law. The Protection of Women from Domestic Violence Act also plays significant role in offering protection of women in abusive marriage. Indian courts continue to deal with this issue in manner that balance constitutional rights with the protection of marriage family institution, reflecting the evolving nature of marriage related to offences in Indian society. The Bharatiya Nyaya Sanhita has introduced the concept of offences against marriage. These are very casual and multidimensional in nature for creating fair and effective legal system. The concerning of matrimonial ties have to be addressed. In my view, laws related to offence within marriage are essential in maintaining fairness and respect in relationship. Marriage is built on trust is violated whether through cruelty, deceit, or betrayal. Legal interventions become necessary. While these laws are meant to be protect vulnerable individuals, that can sometimes be misused, leading to unnecessary conflicts and prolonged legal battles. I believe there should be a balance where the law protects genuine victims without being overly punitive. I believe educations and awareness about material rights and responsibility can play a significant roles in preventing such offences and fostering healthier relationship. Thank you so much for listening such a patiently.
Shivani, thank you very much. It was nice to have an overview of the offences related to marriage. It was a nice, crisp and a good presentation.
Thank you
So
much.
thank you very much, and this is from Hammurabi to you.